This is a Federal News Network podcast.
While Veterans Affairs has been trending in the right direction on some metrics, the failures are still magnified due to the subject matter. A recent Inspector General report found VA failed to identify tens of thousands of Vietnam veterans who could qualify for retroactive benefits. To get some reaction, history, and legal knowledge about what is required of the agency at this point, we welcome Bart Stichman, co-founder and special counsel for the National Veterans Legal Services Program. Bart, thank you for always joining us.
Well, thank you for having me, Larry.
Absolutely. So why don't we just set the table and tell me a little bit about the history of this class action lawsuit that actually involves the NVLSP back in the 80s, which I don't know if you were around then, but I'd be happy to learn some of the insight that you know about that case.
Well, actually, I was around then, and I was part of the team at our organization that filed the lawsuit in 1986. In federal court in California, challenging the VA Agent Orange compensation rules. For people who are younger than me, they may not realize that the United States sprayed, when they were during the Vietnam War, in Vietnam, a herbicide to kill forests where the enemy was hiding as a tool during the war. And this herbicide contained, which chemical companies produced for the government, contained toxic substances that caused illnesses in humans, both Vietnamese and the troops. It contained a contaminant called dioxin that the EPA banned because it was so toxic to humans and animals as well. And so the lawsuit successfully got the court to strike down the VA's position that only chloracne, a skin condition, is connected to exposure to Agent Orange, and required the VA to conduct a new rulemaking proceeding to decide what's connected. And then Congress stepped in 1991 and required VA, in deciding what's associated with dioxin, the National Academy of Sciences, a nonprofit independent scientific entity, to advise the VA. And as a result of that, the VA agreed with the National Academy that dozens of diseases, including many cancers, are connected to Agent Orange. And as a result of that legislation combined with our class action, the VA has been forced to pay billions of dollars, over $5 billion in retroactive benefits to Vietnam veterans and their survivors. And that gives you the background of the case, which is still going on, because the VA keeps adding diseases as connected to Agent Orange, even decades after the Vietnam War.
In the context of it, this was a pretty landmark case. I mean, that rule saying that only that skin condition was associated with exposure to Agent Orange is almost laughable now that not a laughing matter, but just knowing what we know now, how out there that rule was. Where did that case stand in the context of the fight for Vietnam veterans to get this far when it comes to Agent Orange and the diseases it caused in our veterans?
The class action was the key that opened the door. Otherwise, the VA could have kept that rule that only chloracne will be compensated and never compensated for other diseases. So the court's decision did lead Congress to pass the Agent Orange Act, which required the VA to pay attention to actually contract with the National Academy and pay attention to what they had to say about the science on Agent Orange. But our class action, we agreed to a consent decree on who would get paid, and the VA agreed that every time they added a disease, which they started in 1991, and they've continued to add diseases through 2021 to the list of Agent Orange related diseases, Every time they added a disease, they had agreed with the consent decree to find everyone who had previously filed a claim based on one of those diseases, redecide the claim under the new rule that added the disease, and then pay retroactive benefits back to the date of the initial claim.
We're speaking with Bart Stichman, co-founder and special counsel for the National Veterans Legal Services Program. Okay, and so now the problem is, and this came out in a recent IG report, that it appears that VA is not doing what you just said, which is when a disease is added, going back and saying, well, these are the claims that we denied. We do owe this person money now. Is it a case of they are doing a little bit of it, or are they cherry picking which diseases they do it for? Are they doing a little but not enough? What is your standpoint?
They are doing it some. There are 3 diseases that were added in 2021, bladder cancer, Parkinsonism, and hypothyroidism. That's an underactive thyroid. And they've looked, they said, completely for all 3 veterans and survivors who filed claims based on all 3 of those diseases. And they found approximately 70,000 of those, and they're in the process of redeciding their claims and paying retroactive benefits. So that they have done. But then the Office of Inspector General did a review of the accuracy of their search, and they found that the search was half a loaf. The search didn't go nearly as far as it should have, because it found over 80,000 additional people who were diagnosed in the past for one of these 3 diseases, and VA didn't identify them for purposes of readjudication and retroactive benefits. So that's the nub of the problem.
Was there any reaction from VA when you all reach out to them about these kinds of claims? Dollars to donuts, VA is going to be facing a budget shortfall this year and next fiscal year. Is it just coming down to they don't have the resources and money to do so? Or what is the main issue, the reason that they gave you?
No, the IG, before this was issued, they gave VA a draft of their report and asked for their reaction. And their reaction was not, we can't afford to pay these 80,000 additional people. And they wouldn't pay all of them. They have to redecide their claim. And maybe there wasn't a diagnosis, or there could be a reason for denial, but most of them would probably win. And they say they don't have to, for many of these claims that OIG found, they don't believe they're required by our consent decree to identify them, because the records showing a diagnosis of one of those 3 diseases was in a different part of the VA, the Veterans Health Administration, and that diagnosis was never associated with the VA's claims file. And so their objection is technical. The diagnosis was in location A and not in location B, even though the VA possessed it as a whole. And because it was not in location B, the VA claims file, they don't have to do anything.
So where do you all go from here? Are you, I imagine you're going to keep on keeping on for those folks that feel they are owed retroactive benefits. What can, one of those veterans, if they feel or loved ones or survivors that feel they are owed some retroactive benefits for a disease claim from Agent Orange, what is their option? What are their options here?
Their options, first of all, we're going to be dealing with the VA now that this report comes out and get to the bottom of this problem and see what they're willing to do to rectify it. We hope we'll be able to reach some type of agreement with them without us having to go back to court. But if we're not satisfied, we may end up back in court. We've had to go back to court 5 times already for VA resistance to compliance with the consent decree. But as to the veterans, if they have one of these 3 diseases and they haven't been contacted by VA to be told we're redeciding your claim, then I suggested they